A very warm welcome to the 20th Kilbrandon Lecture. My name is Elaine Webster. I'm an academic in the law school here, and I'm Associate Dean for Equality, Diversity and Inclusion in the Faculty of Humanities and Social Science. I will be returning to the chair later this evening, but for now I'm going to hand over to Professor Eleanor Shaw, OBE, who is an Associate Principal with responsibility for the university's entrepreneurship strategy, Strathclyde Inspire, and Director of the Strathclyde Doctoral School. Professor Shaw, I invite you to give the formal welcome and introduce the speaker.
Good evening, everybody. It's really delightful to have you all here. There, thankfully, is no snow in Glasgow. I think in Glasgow, when the temperature actually gets so cold, that prevents any snow or rain or anything. It's just really, really cold. But it's nice and warm in here, so I hope you feel not just warm, but actually a warm welcome from Strathclyde. And I really hope that you are, but I know you're in for a fantastic evening. Now, to some of my briefing notes, and thank you very much, Raymond, for bringing me up to speed with everything. As Elaine said, this is a real milestone because it's the 20th Kilbrandon Lecture, so it's not just any number, the 20th, which is always... What is the 20th? There's the Diamond Jubilee. Does anyone know what the 20th is? No? Snow. It's snow. Snow. It's snow. Well, we can find out, I'm sure. Anyway, I'm absolutely delighted that we're able to welcome Professor Ann Skelton back to the University of Strathclyde. And I know that you're all very much looking forward to hearing what Anne has to say and the contributions that she will be making to this distinguished lecture series. So Anne, thank you very, very much. Anne joins a very distinguished and impressive list of others who've delivered this lecture. Now, with 20 of them, there's too many to go through all of them, but some highlights that I think are in good company with Professor Skelton this evening include Donald Dewar, when he was the First Minister of our Scottish Parliament, Sir Harry Burns, Scotland's former Chief Medical Officer and now Professor of Global Public Health here at Strathclyde, Professor Alexis Jay, who is the Chair of our Centre for Excellence for Looked After Children, CELSIS, and also Chair of the Independent Inquiry into Child Abuse in England and Wales. Last year, we heard from Dr Claire Lightoller, former Director of Scotland's Centre for Youth and Criminal Justice. So you're in very good company, and they too are in good company. The committee, which Lord Kilbrandon established in 1960, led to the formation of Scotland's unique and globally respected approach to care and justice for children, the Children's Hearing System. The hearing system is designed to ensure that children's needs as well as deeds, and that's such an important phrase, isn't it? Needs as well as deeds are considered whenever legal contributions relating to care and justice concerning children arise. Since its inception, the system has contributed immensely to the care of young children and to greater respect being given to the rights and the futures of our children. So what an impressive thing to have set up. This lecture series is a joint venture with the Scottish Government, and it is hosted by Strathclyde School of Social Work and Social Policy. The lecture continues to enjoy the support of Lord Kilbrandon's family, and tonight they're represented by Miss Heather Shaw, not a relation of mine, I'm afraid, but that would be lovely if we were. And Heather is Lord Kilbrandon's granddaughter. She is also a solicitor with an interest in family law. I'm especially pleased that Elaine Webster from the School of Law has agreed to chair the Q&A session. Now, I'm pleased that I'm not doing that, Elaine, because I can imagine it's going to be pretty lively, so thank you for agreeing to do that. And we will also hear from Dr Edward Sosu, from the School of Education, and Sophie Shields from our Institute for Inspiring Children's Futures. They will provide responses directly after Anne's lecture. It's also a privilege to have with us Claire Hawkey, Minister for Children and Young People, who will deliver a vote of thanks following the lecture. And I'm also pleased to welcome Michael Chalmers, Director of Children and Families with the Scottish Government, Elliot Jackson, Chief Executive of Children's Hearing Scotland, Michelle Miller, Chair of Scotland's Children's Reporter Administration, and representatives from local government and the voluntary sector, as well as the Scottish Government and academic colleagues from across Scotland. As if that wasn't enough, we also are very lucky to have with us this evening individuals who are actively engaged in the lives of young people and children in Scotland, some of whom are care experienced, panel members, social workers, healthcare workers, teachers, members of the legal profession, and very importantly, students and young people who are the heart of everything that tonight's lecture and indeed the whole series is focused upon. I would finally like to say a special mention to Professor Kathleen Marshall, also a distinguished Kilbrandon Lecturer and Scotland's first Children's Commissioner. I wish to extend the Principal's and the University's deepest thanks to Professor Marshall this evening in recognition for her important contributions over the past 5 years as the inaugural chair of the board of the Institute for Inspiring Children's Futures here at the University of Strathclyde. And as that term comes to a close, can we just show our appreciation? So everyone is very warmly welcomed this evening, and I hope you have an absolutely fantastic time. Lord Kilbrandon's legacy, our unique children's hearing system, touches all of the professions and services that interact with Scotland's young people. For this reason, this lecture series considers a wide range of issues that can impact on a child's upbringing and explores how all of us together can make Scotland the best place to grow up. Tonight's lecture is a really important part of the university's calendar of events, and I can see just how hard everyone that's been involved has worked on this evening, so many thanks to all of you and everyone behind the scenes for making this happen. As you may know, Strathclyde was formed at the end of the Enlightenment by Professor John Anderson, and his vision at that time was to create a place of useful learning. And that's important. But what is often not spoken about when we talk about Strathclyde's founder is that he wanted right from the get-go to create an inclusive environment that regardless of age, sex, background, class at the time, you can imagine would be very important. You were welcome to come to Strathclyde. And indeed, Strathclyde was the first university in Scotland, if not the UK. Sounds ridiculous to say this now, but to welcome women to study. They were given tokens freely, and they were allowed to exchange those tokens for education. And in his will, John Anderson said that he wanted Scotland's women to be the finest, the most educated women of Europe. And I think that he's done pretty well there. I'm sure you'll agree with me. So I think that's, that deserves a clap as well. So we still focus on inclusion, on useful learning, and we really are very committed. Our founding principles make it easy for us to engage in really high quality research that has impact. And tonight, that research that we will talk about is all about impact that allows us to be socially progressive and to improve the lives of young people. And honestly, I can't think of a better way in which to use research than for that very hands-on practical purpose. And you know, at Strathclyde, we research children from a variety of different perspectives. We're interested in the rights of children, of young people, of families, and we want to experience and to understand their experiences of health and well-being, and look at how we can help them engage in citizenship and communities, and to benefit from social and criminal justice rather than be further disadvantaged. If I turn now, please, finally, to Professor Ann Skelton. Anne, we are deeply honoured to have you here this evening delivering this 20th in the Kilbrandon Lecture Series. Professor Skelton has been a human rights lawyer in South Africa for over 25 years, and she's a globally recognised specialist in children's rights. Anne is an elected member of the UN Committee of the Rights of the Child, now in her second term. She recently co-chaired the UN Committee's General Day of Discussion on Children's Rights in Alternative Care and was chair of the expert committee that drafted the Abidjan Principles on States' Obligations regarding public education and the regulation of private education. As if all of that wasn't enough, Professor Skelton is a Professor of Law at the University of Pretoria, where she holds the UNESCO Chair in Educational Law in Africa. She's an advocate who has played a leading role in landmark litigation, most especially in education. In 2012, she was awarded the Honorary World's Children's Prize. She was at the forefront of legal reform throughout the South African Law Review Reform Commission. Anne was appointed as a full professor in the University of Pretoria's Department of Private Law in 2014. And prior to this, she worked for 10 years in the University of Pretoria as Director of the Centre for Child Law. Prior to joining the university, Professor Skelton was a public prosecutor and a Director of Lawyers for Human Rights. She has also provided technical assistance as project leader with the United Nations Development Programme. Professor Skelton also holds the rotating chair of Enforcement of Children's Rights at the University of Leiden in the Netherlands. And I'm delighted to say that Anne is a visiting professor at the University of Strathclyde, and to let you know that she is also the incoming chair of the Board of Inspiring Children's Futures. Anne, I don't know how you do it all. Anne and I had a chat beforehand, and Anne did explain to me, I hope you don't mind me saying this, that maths was not her strong point, because she realises that if she adds up all of the various fractional appointments that she has, she must have a doppelganger somewhere or an avatar who's taking on board all of this work for her, because she seems incredibly busy to me. So, Anne, we're delighted to have you this evening. I know that everyone's looking forward to hearing what you have to say. So please come up and join us. Thank you.
Well, thank you very much for those kind words of introduction. And I'd also like to thank the Scottish Government and the University of Strathclyde for hosting this event and for inviting me to present the Kilbrandon Lecture. And what an honour to present the 20th one. It does seem a nice landmark moment. Let me add my word of welcome and thanks to all of those that were specifically mentioned by Professor Shaw, and indeed to all of you. Thank you so much for coming out on a cold night. And I did notice that there was a fairground down the road that looked a lot more fun than this. So if you actually walked past or drove past there and still got here, I think that really shows commitment on your part. Thank you. Children of the Beloved Country, Lives and Legacies from Kilbrandon to Mandela is the title of my speech. And it traces the legacy of Lord Kilbrandon in the South African Child Justice Act. But it also connects and interconnects that with other lives and legacies from South Africa, including Alan Paton, Charlotte Maxeke, and Nelson Mandela. The speech will conclude with a selection of some of my thoughts about holistic child rights implementation in South Africa. And I will also talk about the context here in Scotland as you are poised on the incorporation of the Convention on the Rights of the Child. I first came across the name Kilbrandon and the Kilbrandon Report when I was doing law reform on the Child Justice Act in South Africa. And that was in the 1990s. And actually, he also appears as a footnote in one of my, in my doctoral thesis, on one of the pages of my doctoral thesis as well, where there's a lengthy explanation about his work. And so little did I realize then that I would one day be standing up here in front of all of you to do this lecture. But let me take a few steps back before I talk about the law reform to tell you how it came about that I realized that there was such a need for law reform. And that was when I was fresh out of university, having just finished my law degree in 1996. And, yes, 1996, one has to check where you are. No, sorry, 1986. I thought something was going wrong. This is when you've got too many decades to select from. 1986. I had just finished my law degree, and I had a bank loan, so I needed to get a job. And one of the jobs that was relatively well paid was being a public prosecutor. So my first ever job was as a public prosecutor. And in those days, the practice was to get the rookie prosecutors to cut their teeth in what was called the juvenile court. I guess the thinking was that if you made big mistakes, you should do it with little people or something along those lines. So it was really quite a life-changing experience, this, because as I stood in the magistrate's court with this smell in my nostrils of a mixture of disinfectant and urine, and I saw children's faces in front of me behind the dock, mostly African children, and I saw the shabbiness of their clothes and could see their poverty, and sometimes I would see the marks of police brutality on them, dog bites even sometimes. I thought, someone's got to do something about this. Well, as you might imagine, I didn't last very long as a public prosecutor. But I did have an amazing opportunity to be able to work on reforming the system. I left the prosecution service and I joined Lawyers for Human Rights, which was an anti-apartheid movement. And you know, it's interesting that this was 1986, was only 4 years before Nelson Mandela was released. But actually, it didn't feel like we were on, you know, on the crux of a new dawn or anything like that. It still felt as though we were in deep apartheid. And there was still a state of emergency that actually extinguished the few rights that most people had. So human rights work was something that was challenging to do, but very important. So I joined Lawyers for Human Rights, and within a few years, I found myself going back to this issue of children and ended up actually then targeting the rest of my career around advancing children's rights, which just shows that your first job can be very influential in what you do, even if you're not very good at the first job that you do. So Nelson Mandela was released in 1990. And during those years that followed, it was only in 1994 that we had our first democratic elections. There was a flurry of activity as the African National Congress prepared for the first elections and, of course, you know, all the things that needed to happen and needed to change for this new democracy that was being born. And I was really privileged to be able to stand alongside some of the people who inspired us all, among wonderful mentors such as Albie Sachs, who I believe has been here, and the late Dalla Omar. We were literally trying to think and plan about what would this post-apartheid society be like, what kind of laws did we want, where would we look to for our inspiration, and so on. Well then, when Nelson Mandela made his opening address in Parliament in 1994, he said, "The government will, as a matter of urgency, attend to the tragic and complex question of children and juveniles in detention and prison. The basic principle from which we will proceed from now onwards is that we must rescue the children of the nation and ensure that the system of criminal justice must be the very last resort in the case of juvenile offenders." So, of course, Mandela's awareness of children and children's rights is legendary. Everybody is aware of it. And it is it is amazing to think that it's his signature on South Africa's ratification of the UN Convention on the Rights of the Child, because that was in 1995 when he was the president, just 1 year into his presidency. Now, until this time, South Africa actually didn't have a separate piece of legislation for child justice. And so it was that we set about thinking what that new law would look like. I was appointed by the Mandela Cabinet to chair a law reform commission to draft South Africa's Child Justice Act, and I was actually 35 years old at that time. So we started to look around the world to think about where we could get some good ideas from. And we selected 3 countries for this exercise. The first was Uganda, which incorporated interesting aspects of customary law into their child justice system. The second was New Zealand, which, of course, was fated for its family group conferencing based in part on Maori conflict resolution methods. And the third was Scotland, which was famous for its hearing system. So the Kilbrandon report, written in Scotland for Scottish children, reached across the ocean to be added to the big ideas that were going to form the new child justice system in South Africa. Writing elsewhere, I've described the decade-long process of getting that bill written and through a consultative process, including with children themselves, and finally through Parliament as it had to weather storms of popular punitiveness and all kinds of things. But finally, it got through fairly unscathed. And we cannot claim that this act mirrors the Scottish system at all, because it is justice rather than welfare-oriented, albeit that it focuses a lot on restorative justice. However, one aspect of the act that I think embodies, for the first time in South African law, something that one could say comes from the hearing system, and that is this procedural step called the preliminary inquiry. Children who've been charged with an offence under this new Child Justice Act, which has now been in operation for 12 years in South Africa, are not arrested, except in very narrow circumstances where there's an ongoing offence, but they are issued with a written warning to appear at a preliminary inquiry, which takes the place of a first appearance. They are, first of all, when they get there, they are first of all assessed by a probation officer, and these are actually trained social workers in our system, and they can be diverted by a prosecutor at that stage. But if they aren't, then they must come before a preliminary inquiry. It's chaired by a magistrate. The child will be there with his or her parents or other appropriate adults, and there will be, the prosecutor will be there, the probation officer will be there. And the purpose of this meeting, it's done more informally, not in a courtroom, not wearing robes. The purpose of it is to stop and think. Doesn't actually say that in the act itself, but it should, I think. But it is really important to pause and think before you go any further. What are we actually doing here? And it's not an adversarial process. It's an inquisitorial, non-adversarial process. And from there, the court will consider, can we not divert the child? Even though the prosecutor's already declined to do so, it's still possible to get a diversion at this stage. Alternatively, the preliminary inquiry can decide to refer the child to the care and protection system. So although it's not all in one process, like the hearing system, the referral across is very easy at this point. And that's the end of the criminal justice process then for the child. Finally, if it is decided that this is a case where the child must proceed to plea and trial in a specialized child justice court, then a lot of thought will be put into trying to keep that child at home and not in any form of custodial care, but if it is necessary, then it can be done. And there are some strict rules about it. So what we have seen as a result of this preliminary inquiry is there's a huge drop in the number of children going through plea and trial in the child justice system. I'm not going to give you the numbers because it just goes over your head when somebody reads out a lot of numbers, but I can just tell you it's quite dramatic. We can't say it's entirely due to the preliminary inquiry, because even at the front end of the system, we see children are coming out, in much larger numbers as well. But we do think that this stop and think moment is very important, and I think it can be accredited to the legacy of Lord Kilbrandon. The beloved country in the title of my speech borrows from the title of a book by South African writer Alan Paton. His Cry the Beloved Country, published in 1948, just as South Africa retreated into its darkest years of official apartheid following 300 years of colonization, has a story that follows the journey of a Zulu priest who goes to Johannesburg to help his son, who's been arrested for the murder of a white man. Paton's message is that despite the brutality of apartheid, of the darkness and despair of that time, human dignity and human connectedness offers some hope of a future beyond racism, hatred, and fear. Now, what is less known about him, because he's quite famous for his writing and also because he was politically involved in the Union Party, but it's less known that he was the director of a reformatory school called Diepkloof. And he actually wrote a lot of other books and poems, and many of the poems are about the children that he met and worked with. And he tells stories about them, and you feel like you got to know them a little. They have colonial-sounding names like Halfpenny and Pinky, many of them. But I think in other ways he captures some quite beautiful things in his poetry. And I want to just give you a little bit of taste of one of his poems. It's called Death of a Small Child in Diepkloof Reformatory. Small offender, small innocent child, with no conception or comprehension of the vast machinery set in motion by your trivial transgression, of judges, magistrates, and lawyers, psychologists, psychiatrists, and doctors, principals, police, and sociologists, kept moving and alive by your delinquency. This day, and under the shining sun, do I commit your body to the earth, O child, O lost and lonely one. Clerks are moved into action by your dying. Your documents, all neatly put together, are transferred from the living to the dead. Here is the document of birth, saying that you were born, and where, and when, but giving no hint of joy or sorrow, or if the sun shone, or if the rain was falling, or what birds flew singing over the roof where your mother travailed. And hear your name, meaning in white man's tongue, he is arrived, but to what end or purpose is not said. It's not the whole poem, but I think it gives you a little bit of a taste of the fact that he was a man of words, and he brings to life that very problematic system. So he also was a reformer, somebody who wanted to change what he experienced and saw around him. And his experiments with justice and freedom were based on his theory of punishment. He was of the view that beyond the two general approaches to punishment, which he identified as retributive and deterrent, there were two further approaches. The third approach to punishment was what he called reformatory, in which the word punishment would be replaced with treatment. Well, this wasn't Paton's own idea, of course. He ascribed to a broader movement, popular in his time, which is often called rehabilitative. The rehabilitative approach arose at the same time as the rise of social work and probation work and psychology and so on. And as we know, it was quite popular in the first half of the 20th century. But Paton had a fourth approach to punishment, and it was a radical one, namely that there need be none at all. According to this view, steps are taken against the offender for the sole reason to protect society, and if society does not need protection, then the person need not be punished. So as I say, he worked at Diepkloof Reformatory. He tried out some of these ideas. He was there from 1935 to 1948, and he was encouraging boys through a system of graduated freedom. Elsewhere, I've written about the fact, that this was not his own brainchild entirely, but part of a child-centered pedagogy growing in popularity at the time, which stressed the relationship between pupil and teacher and emphasized the individual psychology of each child, promoted the creation of a community and family setting instead of a vast borstal or prison type of approach that had preceded it. Now, whilst Paton's reforms undeniably brought about general improvements for all the boys, there were some aspects of his work that remained very questionable. One was that he actually continued to allow corporal punishment to be used at Diepkloof. And what was particularly strange about this is that he himself had been a victim of corporal punishment in his own home. I'd been pausing to wonder if I should tell you that his father was Scottish. He was. And he obviously had a heavy hand, and this made Alan Paton very unhappy, and yet he repeats it then on, in the reform school setting. And something that I've written about before as well, that is a very little known fact, is that Paton had to have a finger amputated in 1938 after he punched a boy at Diepkloof in the mouth, and the wound made by the youth's tooth became infected and the finger would not heal. And Paton was very religious, so I often wonder, he must have really thought God was teaching him a lesson there. Anyway, of course, the prevailing view of society at the time was that whipping children was a good idea and that you could get across to them this way. In fact, in 1947, the South African government appointed the Lansdowne Commission to investigate aspects of criminal law reform. That commission found that corporal punishment should be retained as a sentence for children and youths. And during the apartheid years, it was used unremittingly as a method of youth crime control. Indeed, it was not until 1995 that the South African Constitutional Court abolished the whipping of child offenders as a sentence in the case of S versus Williams. Paton did manage to reduce the amount of corporal punishment, and he did it by another questionable method, at least from our modern viewpoint, and that is he used tobacco as an incentive. So the boys were very keen on tobacco, and Paton tells an interesting story about he invited a Dutch reform minister to come and give a sermon one evening at Diepkloof, and after the sermon said, well, boys, any questions? And nobody asked any questions. So Paton was encouraging them, said, come on, boys, you can ask anything. And one boy at the back said, a bit of tobacco, sir? So I think other writers as well have pointed out that there was, Linda Chisholm, for example, has observed that in all of this there was a fine irony unseen by Paton himself, for he maintained the fiction of freedom as a reformatory instrument while training African boys for a poverty, farm labor, and unfreedom that they did not choose. At any rate, by 1946, he was getting pretty frustrated with his own situation because he wasn't able to do all the reforms that he wanted to because the government was getting more and more narrow-minded as things were going on. So he took an international tour to look at other reformatory schools. He went to the United Kingdom, Sweden, Norway, and the United States. And I find it intriguing to think about the fact that he might have come to Scotland, where he would have met with Scottish reformers. Could he possibly have met with Charles Shaw? Not yet called Lord Kilbrandon, Shaw was, at that time, in 1946, a senior advocate. It was only in 1949 that he was nominated Queen's Counsel. I'm right, aren't I, that it's still Queen's Counsel if it was in 1949. It hasn't suddenly changed overnight to be King's Counsel. Yes, I thought so. And then, in 1959, he received his traditional life peerage as Lord Kilbrandon. So Alan Paton and Charles Shaw were contemporaries. Paton was born in 1903 and Charles Shaw in 1906. And they died within a year of one another in 1988 and 1989, respectively. Certainly, they shared some similar views. A major finding of the Kilbrandon report was that all juveniles under 16 should, in principle, be removed from the jurisdiction of criminal courts. All existing juvenile courts should be abolished. The aim, of course, as you well know, of the hearing system was to supervise special measures of education and training according to the needs of the individual child. And I can hear the ring of an echo there with Paton's ideas about the abolition of punishment and the need for rehabilitating education. The early part of the 20th century was a time during which a welfarist approach to child justice was favored worldwide. In fact, in 1935, the League of Nations undertook a survey of 43 countries and found that 32 had established special children's courts that were welfarist in their approach. But then, over the years, the welfarist approach waned in popularity and started to be replaced with more justice and more punitive systems, justice-oriented and punitive systems. So in a sense, Lord Kilbrandon's report in 1961 it's late. How can I put it? It's out of fashion. The fashion was gone. But somehow or other, he managed to convince the people at the time that this was still the right way to go. And for that reason, Scotland has managed to hold on to this very unusual system. It wasn't so unusual in the 30s and 40s, but it is unusual now. So I want to, because we're going back to the first part of the 20th century, I want to also introduce here a towering figure in South Africa's history, Charlotte Maxeke. Now, she wasn't a contemporary of Lord Kilbrandon, as she was born much earlier in 1869. Recent historical accounts by South African authors Tembeka Ngukai Tobi and Zubaida Jaffa have breathed new life into Charlotte's early years when she travelled with the African Jubilee Choir to England and spent a year in the UK from 1891 to 1892, where she performed at Queen Victoria's Jubilee concert in the Royal Albert Hall and also met with suffragette Emily Pankhurst. Charlotte subsequently went to America, and she graduated with a BSc from Wilberforce University in the United States in 1901. And all this before Charles Shaw was born. And she came back to South Africa as the first black woman with a degree. Less known is the fact that the multi-talented Maxeke was South Africa's first black probation officer. And she worked with children in the criminal courts while simultaneously serving as a child welfare officer in Johannesburg from 1923. According to Jaffa, she worked with waifs and strays and destitute children and was credited with having done considerable work in the alleviation of the causes of crime in the city. However, she was discharged in 1929, and according to education historian Linda Chisholm, the relinquishing of her services was a sign of both cost-cutting exercises in the context of the Great Depression, as well as the steadily hardening segregational program of non-recognition of the right of Africans to be in urban areas. Maxeke, like her Western counterparts, worked on child rights issues some years before they themselves had the vote. White women got the vote in South Africa in 1930. Despite working on the campaign for women's suffrage with women of all races, Maxeke herself was never able to cast a ballot, not because of her gender, but because of her race. She died in 1939, and women were allowed to vote from 1930, but Africans did not get the vote until 55 years later in 1994. Another South African woman who, due to her race, did get the vote in 1930 was Leila Rates. Having obtained the right to vote, Rates stood for Parliament, and she became the member for Parktown in Johannesburg. She was the first woman elected to the South African Parliament in 1933. She served as a member of a government committee established in 1934 called the Interdepartmental Committee on Destitute, Neglected, and Delinquent Children and Young Persons. The committee's terms of reference included the instruction to consider whether it is desirable and practicable to dispense with criminal procedure in dealing with juvenile and/or juvenile adult delinquents, and instead to deal with them paternally on the lines of the procedure adopted in administering the Child Protection Act. So in other words, they were looking at whether or not they should do away with a punitive criminal justice system and replace it with a welfare-oriented system. The committee's report of 1937 made a remarkable statement for its time. It said, "The draft bills submitted by the committee make no distinction on racial grounds. The principles underlying the treatment of children in need of care or of delinquents are of equal validity, whether the children to whom they apply are of one race or another." In an impassioned speech to Parliament, Mrs. Rates said, "I want to make it clear to the House that if we do not bring in a comprehensive measure such as I have outlined, we shall fall very short indeed, not only of what other countries have achieved, but certainly of what must be done in this country." I'm sorry to tell you that the Young Offenders Bill did not pass, despite the work put into it by the reformers. That opportunity was missed, and South Africa entered a long period of stagnation and deterioration in the field of the rights of children in the justice system, which lasted over 40 years. There does seem to be a seminal lesson for would-be reformers here. Do not miss a big opportunity. It wasn't until 1995 that the Mandela government ratified the Convention on the Rights of the Child and put in motion a process for the drafting of South Africa's first separate piece of legislation for child offenders. And finally, in 2010, the Child Justice Act was passed. South Africa's ratification of the convention was indeed pivotal, but it is the work that's done afterwards as well that is very important to implement that. And I think that we can see, if we look at what's happened subsequently, how the convention and the constitution working together have made such a difference. South Africa has one of the most comprehensive sections on children's rights in any constitution in the world. And this was influenced by the ratification of the CRC. The convention and the constitution have been embedded into South Africa's laws about children, into our planning, into our budgeting, into our service delivery. When there are failures and weakness, and I acknowledge there are many, the Convention and the Constitution have been instrumental in promoting accountability. As I have spent most of my life working, trying to advance the rights of children within a constitutional democracy, I've come to know the value of that Constitution. I've come to know its power. Let me give you an example. The last case that I argued in the Constitutional Court was on the constitutionality of the defense of reasonable chastisement. In other words, it was about corporal punishment in the home and the special rule that if parents hit their children, they would be exempted from prosecution. Now, the Chief Justice at the time, he's not the Chief Justice anymore, was a conservative Christian. And when he hears the words corporal punishment in the home or defense of reasonable chastisement, I imagine that biblical epithets jump into his mind immediately. So, to put it mildly, he didn't like the arguments that I was making. It was a rather difficult day, I must say. And as we waited for judgment, it took rather a long time. I did start to get a bit worried. But deep in my bones, I knew that we had to win. We had to win because we have a constitution that says that everyone must be protected from violence, from public and private sources. And children are people. In fact, they're the most vulnerable and most dependent people. So therefore, surely, they must be protected from violence. And I also knew we had to win because the Convention on the Rights of the Child, as interpreted by the Committee on the Rights of the Child, makes it clear that corporal punishment is not acceptable. And the legal system in South Africa requires that when interpreting a right in the Bill of Rights, that has to be in line with international law. So that importance of compatibility is absolutely crucial. And so, I was right. We did win. But when I read the judgment, there's something a little bit off about it. And this is what it is. You can see that the Chief Justice did not want to do this. It reads a little bit as though someone had a gun to his head. And he did not want to do it, but the Constitution made him do it. That was the gun to the head, and that is the power of it. So this brings me to Scotland's decision to incorporate the Convention on the Rights of the Child. What is the power of it? It is the importance of the compatibility of the Convention on the Rights of the Child with Scotland's laws, policies, plans, budgets, and its actions through its public authorities. It's the lodestar of actions in respecting, promoting, and fulfilling children's rights. So let me put on my UN Convention on the Rights of the Child hat. And I'd originally thought about having a Christmas hat over here and putting it on and then saying, oh, sorry, no, that's the other committee, that's the Christmas Organizing Committee. But Jennifer thought it might be too silly for an occasion like this. No, she didn't. She said I could act it out if I really wanted to. She wouldn't get me a Christmas hat. But anyway, no, being serious, I'm putting on my Committee on the Rights of the Child hat now. And I just want to make an important disclaimer. When the United Kingdom comes to the Committee on the Rights of the Child with its report on its progress, which is soon, in May, I will not be sitting as a committee member. The reason for this is that I was born in the United Kingdom, and in fact, my mother was born in Kirkintillich, so I'm half Scottish. It's this half. And therefore, I'm not allowed to sit when the United Kingdom is being reviewed. I'm also not allowed to sit when South Africa is coming, because this half of me is South African, and therefore I have to recuse myself in both instances. But I will be in the room, sitting in the audience, I would imagine, amongst some of you. So I'll be very interested too to hear what's going to be said. So I have to speculate about what the committee will say, because I actually don't know, because I won't be able to even be involved in the discussions about this. If I were, I wouldn't really be able to make this speech, in fact. So let me say that I think the committee will be paying attention to what Scotland has committed to in terms of its children's rights promises. The committee does not, of course, see the United Kingdom as a monolithic entity. It does understand that it's made up of different entities, and it is very aware of how Scotland differs in its approach and actions from, for example, England and Wales. In fact, it's even aware of how Wales differs from England and Wales. But I think that the committee will ask questions. They'll be full of praise for the progress that has been made. And they will ask questions about, so where is it now? How far has the process got? So my respectful advice is to ensure that Scotland retains its exceptionalism, and not just in repeating promises about children's rights, but in showing what it has done to realize those promises. I believe that Scotland is standing on one of its historic moments. Of course, it's not possible to make exact comparisons with countries as different as South Africa and Scotland, and I'm not trying to do that, but what I hope I have shown in my speech here tonight is that when big opportunities come up, it's important to grasp the thistle. I'm respectful of the fact that Scotland is facing challenging times, but an investment in children always pays dividends. The Committee on the Rights of the Child, in its general comment on public budgeting for children's rights, has indicated that even in times of crisis, it is not permissible for states to take retrogressive measures. And as all economists know, sometimes just standing still is retrogression in real terms. Let me end on another heartwarming promise that Scotland has made: to remove all young people below 18 from placement in prison or young offenders institutions. This, too, is a crucially important step in the evolution of Lord Kilbrandon's legacy. I'm sure that if he was here, he'd be urging the passage of the bill with all speed. To return to the title of my speech, Children of the Beloved Country, whether they are here in Scotland or in South Africa or anywhere, we must continue to walk the paths of the great reformers from Kilbrandon to Paton, from Maxeke to Mandela, and we must walk on into the future. Let me close my speech by taking you back to the second half of the poem I read from earlier, about the death of a child in Diepkloof Reformatory. And I read it in the memory of children and young people who have died in custody in Scotland in recent years, and indeed in the memory of all children who have died in custody everywhere. Here is the last certificate of death. For stalling authority, he sets you free. You that did once arrive have now departed. You are now enfolded in the sole embrace of kindness that earth ever gave you. So negligent in life, in death, belatedly she pours her generous abundance on you and rains her bounty on the quivering wood, and swaddles you about where neither hail nor tempest, neither wind nor snow, nor any heat of sun shall now offend you. And the thin, cold spears of the high-felt rain that once so pierced you in falling on your grave shall press you closer to the deep, repentant heart. Here is the warrant of committal for this offence, O small and lonely one, for this offence in whose commission millions of men are in complicity. You are committed, so do I commit you, your frail body to the waiting ground, your dust to the dust of the veldt. Fly, homebound soul, to the great Judge President, who's unencumbered by the pressing need to give society protection, may pass on you the sentence of indeterminate compassion. Thank you for listening.
Thank you so much, Anne, for that very rich and very moving journey that you've taken us on, from seeing those faces of the children in the courtroom to all of the work that you've done today in the service of children and children's rights, including internationally, and for sharing your wisdom on the importance of the Convention on the Rights of the Child. And thank you for weaving together those stories of South Africa and Scotland, the changes and the developments and the systems and approaches, and also the role of individuals within that. And of course, you placed children at the heart of that, whose, as we know, whose rights are still often not adequately recognised. I had the pleasure of visiting the South African Constitutional Court just a few months ago for the first time. And it was very, very powerful, and those points that you made really struck me. And I have to say, it was surprising to see there were children everywhere, buses of children all visiting the Constitutional Court, which I'm not sure if it's the same at the Supreme Court in London, but it was a really wonderful thing to see. So we'll soon have time for some reflections and questions from the floor. But before that, I would like to introduce two very dear colleagues from Strathclyde to share some reflections on the lecture. First of all, I'm going to invite Sophie Shields to speak. Sophie is a knowledge exchange practitioner based at the Institute for Inspiring Children's Futures. Sophie's expertise is in environment and participation, and she also works on children's human rights and the environment. Sophie will be followed directly by Dr. Edward Sosu, who's a reader in the School of Education. Edward's research focuses on exploring how socioeconomic disadvantage influences educational and psychological trajectories from childhood. So, Sophie, I'd like to invite you to come to speak.
It's so wonderful to be here this evening. It is really such an honour. And first, I would like to extend some massive thank you to Professor Ann Skelton for sharing what I think is a piece of living memory with us all tonight. So thank you, Ann. My response to Ann's lecture, I hope might help us further locate Ann's experiences in South Africa and at the international level in our own unique context in Scotland, as we continue to embark on our journey to realise all children's human rights. From the beginning, Scotland's incorporation ideas have been set out to be ambitious and maximalist. In March 2021, the vote to incorporate the Convention into domestic law was passed unanimously. And indeed, around the world, many, including Anne herself, have noted the ambitiousness of this incorporation approach. This approach is a landmark moment for Scotland in its human rights journey, as the first legally incorporated UN Human Rights Treaty in Scotland, the first convention specifically for children's human rights, and the first economic, social and cultural human rights law obligations to be given force within our national legal system. And it comes as a separate but parallel human rights process which has been underway for over 2 decades, where Scotland will also incorporate 4 further UN human rights treaties. This is a mission and an aspiration to be a global leader in human rights. For a Scotland where everyone lives in a culture which upholds human rights, where everyone has what they need to claim their rights as their own, and to live a life of dignity and equity. There is no clearer opportunity, in my opinion, than to get this right for every child from the very beginning of life. Scotland's approach to incorporation has not went off without a hitch, as many of you might know. We do live in a unique constitutional settlement, of which I've been honoured to give Anne some insights into. And so we'll know about the Supreme Court's challenge to incorporation and times where we face the repeal of the Human Rights Act and a very weakened British Bill of Rights. But still, a founding characteristic of Scotland's movement in the face of adversity in almost 2 years since the bill's passing is founded on hope, responsibility and courage to improve children's lives, from children themselves and from the adults who have key roles in their lives. So when Anne speaks about the opportunity in South Africa in 1996 to take a blank legislative canvas and start from scratch, fortunately in Scotland there is no blank slate. We're fortunate that there is already excellent laws, policies, strategies that make real differences in the lives of children and families. The Scottish landscape already considers the standing of the Convention on the Rights of the Child as an instrument of international law, alongside various other policies and strategies and legislation, like the Children and Young People Act, GIRFEC, Child Wellbeing, Keeping the Promise, and many others, alongside a spectrum of incredible work that goes on across civil society and communities to deliver a Scotland which is one of the best places in the world to grow up with children at the forefront. Our efforts to date with and for children do amount to a complex landscape where there can be a bit of a reactionary response to the movement to incorporate the UNCRC. But that doesn't mean that the CRC should serve to further complicate, but to simultaneously offer an underpinning and overarching framework so that we can ensure that we can see where we're still not quite getting it right. A key feature will be how successful we are in facing both the substantive issues, which might need further attention, and how we take a sustained and procedural approach in mapping out processes and steps to realise the human rights of all children. There are gaps which will emerge post-ERC that we can then plan to respond to, but importantly, there are gaps that we already know exist, and this can help us with a framework to overcome that. We might question why now, and Anne spoke about in South Africa, there was a missed opportunity that took 40 years to rectify. And so this is about knowing when to spot the moment and going for it. And to me, this journey we're on now is about seizing opportunities against the backdrop of and in spite of compounding crises. This incorporation sparks real conversations about making real change to people's lives. That goes from the national level all the way down to individual improvements in individual children's lives. And so things like being participation-focused, child-friendly, people-centric, is undoubtedly essential, but it's certainly not sufficient to realise the full benefits of the Convention of the Rights of the Child, which I see as a transformative document, particularly for us in the delivery of socio-economic outcomes. Children, and particularly those already facing adversity, are amongst those most at risk of being left behind and not having the plenary of their rights fulfilled. Our incorporation has to prioritise those rights as levers of real change. And this is really important in our current context. First, as we grapple with the legacy of COVID on our rights, well-being and essential services, but also facing the immediate cost of living crisis and the concerted effort required at every level and all levels to ensure we prevent further regression, especially for those already facing hardship, including our women and children. And finally, we're acutely aware of the immediate, short, medium and long-term impact of environmental and climate crises on our children, who will be amongst the most vulnerable to that. What this means is that we now face times where failing to progress is by very nature regression. The UK will still soon have to stand up and account for why decisions are made that might fail their obligations. And so while we in Scotland face a complex backdrop in every level and every sector which challenges our ambitions to be world-leading and to deliver real change in the lives of children and families, these are obstacles that must be faced head-on, as to do nothing is to make things worse. Anne speaks in South Africa of human dignity and human connectedness, which, although we can't compare Scotland and South Africa, are shared global features of humanity, across, between and within countries, regions and cultures. And so I say that in any approach, honouring dignity, equity, human rights and togetherness will rarely lead you astray. Thank you.
It's an honour for me to be here and to respond to the very insightful lecture by Ann. So I'm going to focus on three key points, and two of which are challenges, and one of which is a message of hope. So the first one is around the notion of interconnected lives, and the idea that what we do in one context can have wide-ranging impact on the lives of others elsewhere in the world. And Ann's lecture has beautifully illustrated this interconnection with the work of Lord Kilbrandon influencing child reforms in South Africa. And I will also mention that the work of, let's say, somebody like Nelson Mandela, which is focused on freedom, on forgiveness, on inclusivity, and for us in Glasgow has also given us Nelson Mandela Place. So I think what is important from this example is that it gives us hope that whatever we do in our own small ways might one day or in the future improve the lives and well-being of millions of children around the world. So that should give us hope, and we should continue to do that. The second issue I would like to touch on is the notion that we can have very same or similar ideas, but the way in which these ideas are implemented can differ. So here I draw the distinction between Lord Kilbrandon and Alan Paton. So while on a very light note, on a serious note, they both think about the right of children and having children at the center of any decision making, the way in which this is implemented is slightly different. So for example, on a very light note, Paton thought that the ingestion of tobacco was a very useful way to achieve this child-centered approach. But on a very more serious note, what this shows to us is that policies and ideas in themselves are a necessary condition, but they are not sufficient in themselves. The actions we take and how we actually implement these policies are equally important. So if we take Scotland, for example, we have a lot of policies that are geared towards improving the lives of children and children experiencing multiple disadvantages. But we need to continue to ask ourselves and continue to look through these policies and our actions to make sure that the actions we are taking is actually improving the lives of children and young people. The final comment is around the notion of silent heroes. And here I noted the work of Maxeke. I'm trying. Yeah. And I want to say there are a lot of silent heroes in this room, and dare I say a lot of silent heroes who are not present here. This includes parents, teachers, social workers, lawyers, charity workers, brothers and sisters, uncles, who have over the years dedicated their lives to supporting children and helping children to flourish. But what we also know is that the current economic crisis is placing pressures on these silent heroes, which means that their capacity to be able to absorb and support the most vulnerable can be quite limited. So we need to think about how we can continue to support these silent heroes, to continue to support the future generation. And I also want to take this opportunity to say to those individuals a big thank you and to continue the good work. Thanks very much.
So we now have some time for questions or reflections from the floor. If you could give a wave, raise your hand if you would like to contribute. Yes, please.
Hi, Gordon Main from Our Hearing's Our Voice. Thanks so much for your lecture. It was fascinating and inspiring. We're at a stage in Scotland where the hearing system is facing one of its greatest times of reform. Much of that is based on children's voices and their views and their expertise. I wondered from the South African perspective how much of that expertise was gained from children.
Shall we gather some together?
I think respond to them.
One by one?
Yeah.
Okay. Well, it's great to hear that. And I must say, at the Committee on the Rights of the Child, this is something that we are really emphasizing. Children's voices in the reform process in South Africa, we held consultations with children all over the country on the new bill. And there was a publication that was done that then fed into some of the provisions. Particularly, I remember aspects relating to what would happen if your parents couldn't be found, and what children's suggestions that they made about how to try to find other appropriate adults and that kind of thing probably led to, instead of saying parent or guardian, we ended up with something like parent or other appropriate adult, and we had a list of who might be appropriate adults that came from children. So that stands out in my memory, but although it wasn't the only thing. I'm not sure if I'm answering your question accurately, but it's very good to hear that the children and young people are being involved in reform processes. It's certainly something that the committee will be very interested in hearing about.
I probably don't need this. David Grimm, pleasure to meet you. You all did brilliant. I've been trying to think of how to say this without sounding like a doomsayer, but that's kind of my role in Scotland. I am a doomsayer. I've been around long enough now to see bills and legislation be passed and something falls short of it not being integrated into the actual fabric of our sector of society. So I'm thinking of the Children and Young People's Bill 2014 that was monumental, but then it fell short because of language that had been built in by government. The thing, I know we're going to get this bill because you're all fantastic, and the UNCRC is going to be part of Scotland because we all want that. My question is, I think, and this might not be answerable, how do we make sure that it's interwoven into every part of our society? Because just from being on the ground, I'm a social work student, by the way. I'm not as fancy as some people in the room, but from being on the ground, there's still a real sense that children shouldn't be entitled to rights, and that parents should be the be-all and end-all, and that's coming from really good people also. So that's a very convoluted question. I apologise. But essentially, how do we go about making sure it's interwoven from the very highest of our government to the children themselves? And like I say, it may not be answerable. But other than that, thank you. That was a great lecture.
Well, let me have a go. A question that I'm quite often asked by students, because I'm a teacher, is, but what's the good of this UN Convention on the Rights of the Child if it doesn't actually, reach ordinary people on the ground, and how come it really has no teeth at the end of the day, and what's the point of it all, really? And I think the answer really is that it is a tool that we all will have to join hands and use together. In other words, it isn't a magic wand that suddenly changes something overnight, but it is a standard which is a world standard, and when a state says we're going to do this, then the people in the state can also hold the state accountable and say, well, are you doing it? And we're trying to do it, and we are seeing these barriers, so how are we going to move those barriers? So I guess it's part of that, and having conversations with people who already think that children have too many rights. Yes, it's the sort of thing that when I'm sitting on a plane or in a train and the person next to me asks me, what do you do? I'm dreading what the next hour is going to be like. But it's part of our job to actually explain. It's not that children may or may not have rights. They do have rights. That's the point. They do have rights, and we must ensure that is recognized and that is seen in the way that they are dealt with, in the way that society deals with them. But ultimately, the responsibility for fulfilling the Convention on the Rights of the Child does rest on states. But part of that responsibility is disseminating that message to everyone in society as well. But perhaps my colleagues have other things to say.
I'll move this over in case I'm a bit quiet. Yes, agreed. But I think there's something in this that's quite unique, that is both a mechanism that sets standards and also something that could be claimed by individuals. So it's quite unique that simultaneously human rights can be something that children from maybe their first days in school, as we see now in loads of schools around the country, and a concerted effort that people like the Scottish Youth Parliament have been on for years and years to get us to this point, can equip children with tools that they need to have that agency. Not a right to be cheeky. Like when you're saying parents have the say, that's not what it is. I think in sort of maybe development schools of thought, quite often children are seen as having rights that are to get them to the point of adulthood, their right to become an adult. And it's more about that, and it's less about that and more about childhood as a unique set of circumstances, and it's different for every child. So it's less about little adults and more about humans, in my opinion.
Well, very convoluted, so thank you.
So, as a teacher and a psychologist, I have to say, well, there's something that we know around the theory-practice gap, policy implementation gap, and I think one of the reasons for us to understand why that is the case, and an approach might be to already engage people in the discussion so that even if people disagree, they know and understand what it is they are disagreeing on. And then with time, you hope that there is going to be a response shift over time. Otherwise, I think for most people, it's probably either detached until it is much closer to them, either in their work or they find themselves at the other side of the law. So I think that national discussion is necessary for people to really understand what it is they are talking about. Yeah.
Over here first, please. Yeah.
Okay, thank you. My name's Tam Bailey, and I suppose I'm continuing a similar theme here. And it's lovely to hear the parallels between Scotland and South Africa. And it makes you feel quite proud about where we're at and what we've got going for our children. And there's lots of great things that are happening in Scotland for our children. But as a former commissioner, I used to be in the business of reporting to the committee. And most of the time we're reporting to the committee about failed policy and legal implementation. And you touched on this, Edward, in your input. And I suppose the big question in my head is, it's fantastic that we're in the threshold of incorporating UNCRC, but what can we do to make sure that it's not one of a long litany of failed policy implementation, because we've got plenty of them. And I'm sure the committee will have a richness of questions to quiz the UK and Scottish representatives, because there's lots of places where we're not doing as well as we should, and we're not fully implementing the policy and legal landscape that we live in. So how do we make sure that this potentially, really big moment, that we don't lose it? A bit, look, picking up that theme. And I think it needs a bit more than just discussion. I think we really need to think about some of the safeguards and some of the monitoring and some of the ways that we go about implementing the incorporation of UNCRC. So you might be repeating yourself. My apologies. Yeah, I would like some insight on that. Thank you.
Well, I think maybe one of the issues to think about is that incorporation is something new, but it isn't something new. Because in a way, your policies and your laws and everything are already there. And this comes in order to provide, I think you said, an undergirding and an overarching, what did you say? So you had a nice way of putting at it, like
underpinning and overarching.
Underpinning and overarching at the same time. Very good. So yes, I think that's a good way of putting it, and a kind of gap filler, and also a way of actually going back over some of those failures, if they still matter, if they're still current, and saying, how would we fix this in a system that has to be compatible with the Convention on the Rights of the Child, but really has to be, as in accountability flows from this. So I think, on the one hand, it's an opportunity for everyone to do some thinking together about how to better fill those gaps and use the opportunity to, because I guess there'll be a lot of, not completely rewriting, but just some rethinking and rejigging around planning, budgeting, that kind of thing. And when that work is done, could be good moments to start saying, but we know that won't work because we had this experience, and bringing that. So an inclusive process that has people there who know what can work and what hasn't worked and so on would be important as well, I would imagine. So those would be just some of my thoughts as a visitor to Scotland, obviously not having all the insights that you do. But it seems to me that this is what the opportunity is that it presents. Not as something completely new, but a new take on what you already have and a new framework in which to re-explore that.
Thank you. So, question here. So we're coming to the end of our time. So if I can gather these next few questions together. So here, and then in the middle, and then the gentleman at the back.
Thanks. I'm Bruce Adamson. I'm the Children and Young People's Commissioner here in Scotland. Thank you so much, Professor Skelton, for the amazing presentation, and all of you. I was really struck by the idea that not to miss these opportunities, and also what children and young people tell us so strongly about the need for that accountability, the power dynamic that exists. Children and young people have been right at the forefront of this campaign on issues like incorporation, but also age of criminal responsibility, also not having children in prison. So child human rights defenders, and I know that's something you've led on and the committee's really led on. One of the things I'm really concerned about is hearing from them the disappointment and frustration about the length of time that things take. Nearly 2 years now from the unanimous decision of the Scottish Parliament. 2 years is a very long time in children's lives. And so I wonder if there's a message that any of you have got for child human rights defenders, and also for those that make decisions about the importance of time in children's lives, and the fact that grabbing the opportunity has to be seen within the context of children's lives. And so many of the children that have been involved in campaigning are now adults. And 2 years is a very long time in a child's life.
In the middle, please.
Thank you very much for the absolutely fascinating presentation. My name is Katarina Kasper. I'm the chair of Children's Hearing Scotland. And I was absolutely intrigued to hear about just the success of legislative reform in South Africa. And I think to some degree, without diminishing the effect and the outcome, if you're starting from a low place, it's incredibly rewarding building this up and achieving something that's fundamentally different. Fascinating to hear how obviously Children's Hearings Scotland was a model and one of the examples that you've considered as part of that. And the problem, I suppose, it is a problem that we hear sometimes, is that Children's Hearing Scotland is being described as the jewel in the crown of Scottish civic life. So, it is being held up to this really, really quite high standard. And also sometimes what I hear is like, well, if it ain't broke, why fix it? But we are just now at a time of really big change. And I would just really like to hear, your kind of arguments to help us really, push the message that no system is perfect. And even though we are very, very good, there is still room for improvement.
Thank you. So, final question, and I'm afraid we're out of time, and I'll ask you to give a brief response. Thank you.
Hi, thank you very much for the absolutely brilliant presentation tonight. I loved it. I'm Andy Kendrick, former Professor of Residential Childcare here at the University of Strathclyde, and I've just finished a 200-year history of the development of childcare services in Scotland. So I hear what people are saying, and obviously change is felt to be needed fast and always does. But in terms of the long view, I think we do need to recognise where we have got in Scotland and in terms of services around the world from where we were when you're talking about Alan Paton as head of a reformatory. At the time of Kilbrandon, there were government inquiries into the scale of abuse in terms of the overuse of physical corporal punishment in approved schools in Scotland. I'm currently doing some work on the whole issue of the way in which punishment has been used in residential and in foster care in Scotland, and huge difficulties around that. So yes, we do need to improve, we do need to take things forward, but I also do think that we are in a very different position now than we were even when I started in social work back in the late 80s and early 90s.
Thank you. So I'll ask the speakers to give a very brief word before we close.
Okay, thank you. Bruce, you're right, of course. And working with children as you do, you're hearing it from them, so you know that, telling them that things will be better in a few years' time when they're not, they'll be over 18 by then, doesn't satisfy them at all. So that indeed is a good reason for acting swiftly and taking matters up urgently. The point about the fact that when you're starting off a low base, yes, I think that's a very good point. And I should also, be wary of suggesting that everything is good in South Africa now, which it really isn't. I mean, there are a lot of problems. It's just that we've got good tools for trying to fix it, is what I'm really trying to say. And I guess that's the message I would say is, it is definitely harder to make positive changes within a system that is already good but could be better. And to get the energy moving on things is tricky. But then perhaps that links to the last speaker who points out that it's better now than it was 20 years ago. So there is a trajectory over time and that we have to carry on doing this work of incremental reform. Maybe it's, we've said Scotland's poised on a big change, but it's also poised on a lot of little changes. And basically, you've got to keep the energy going so that you can achieve all of that, the big and the little, the short term and the long term. It's a challenge, but I think maybe best seen as a journey. And you're at an important vantage point. That's really, I think, the message that I would like to end on is, don't lose the momentum. Seize the nettle or the thistle, whichever you think is the more appropriate.
Thank you very much, Anne. I think if Edward and Sophie don't mind, we might leave the last words to Anne. Yeah, just thank you all for your contributions. And so to close the lecture, we're delighted to have the Scottish Government Minister for Children and Young People with us this evening. Minister, I invite you to give the vote of thanks and closing remarks.
Thank you very much. And for those of you who are really interested, the 20th anniversary is China. So I hope you're going to get a tea set. Dr. Webster, distinguished guests, colleagues and friends, it is my pleasure to thank Professor Skelton for delivering the 20th Kilbrandon Lecture, Children of the Beloved Country, Lives and Legacies from Kilbrandon to Mandela. Professor Skelton, in delivering your lecture, you have demonstrated your commitment to using the United Nations Convention on the Rights of the Child as a vehicle for meaningful and lasting change. And you have generously shared not only your expertise and your experience, but also your deep professional and personal commitment to improving the life chances of young people. Most importantly, you've underlined the need for ongoing reform to meet the evolving needs of children and families. We want all Scotland's children to grow up loved, safe and respected so that they reach their full potential. And a central part of our vision for the future is the recognition of, respect for and promotion of children's human rights. And that's why, as we heard earlier, the Scottish Parliament unanimously passed the UNCRC Incorporation Scotland Bill. And this landmark legislation aimed to incorporate as much of the Convention as possible into Scots law. Although the Supreme Court found some provisions to be out with the lawmaking powers of the Scottish Parliament, we remain committed to the incorporation of the UNCRC to the maximum extent possible, and preparation to return a revised bill to Parliament via the parliamentary reconsideration stage is well underway. A robust rights framework enshrined in law will give us a strong foundation for helping our children and young people who are most in need. And the findings of the Independent Care Review offered Scotland a significant challenge. I take the chance tonight to reaffirm the Government's commitment to rising to that challenge. Keeping the promise must mean transformational change, including change to our cherished and admired children's hearing system. We must ensure that the modernised system's redesign delivers for every child in every part of Scotland. In other words, children's experiences must match our excellent principles. The Independent Hearing System Working Group, chaired by Sheriff David Maxeke, is currently working with our key partners to consider what a modernised hearing systems could and should look like. And I believe that we have a unique chance to change outcomes for our care experienced children and young people for the better. Kilbrandon's vision of an effective and integrated justice and welfare system for our children and young people is an enduring one. And I know that those who are working with David Maxeke on these vital reforms hold the values and principles of the Kilbrandon report close, even as they look into the future. Whatever changes we make, they will reflect those principles. Professor Skelton, my colleagues and I will take the learning from tonight's lecture into the work that we will be delivering in the coming weeks, months and years. I want to recognise the insightful contributions of Dr. Sosu and Ms Shields to tonight's events, to thank you very much for your contributions. On behalf of the Scottish Government, I would like to convey my thanks for the continuing support that the School of Social Work and Social Policy and wider universities give to this lecture series. I'm pleased to hear that the University of Strathclyde's Scottish Journal of Residential Childcare is producing an edition that will contain a published version of tonight's lecture. And I also know that a copy of the lecture and recording will be available on the Kilbrandon website, which the university hosts. I would like to thank Raymond Taylor from the University for organising tonight's lecture, and also Nadia Mitchell for her meticulous work in the university's events team. And I want to convey my sincere appreciation to all of you who've come here to hear the Kilbrandon lecture tonight, particularly those of you who are directly involved in supporting Scotland's children through the hearing system. I know that we have children's panels members. We've heard from their chair this evening, children's reporters, social workers, teachers and other childcare professionals with us here this evening. And since the inception of the children's hearing system, you and your colleagues have made an enormous difference to the lives of countless children and their families. Professor Skelton, your thought-provoking words have challenged us all this evening, and I thank you for that. We are immensely grateful for the unique perspective you've brought to the 20th, the China Kilbrandon Lecture. Ladies and gentlemen, thank you once again for your attendance, and I would encourage you to remain, to mingle, to network over a glass of something to finish the evening, and I'm sure there'll be many, many more interesting discussions as the evening goes on. Thank you.